Oh. Mic check. Are y'all ready for Judge Manning? What's up, Tread? What's up, chat? Cheers, Eddie. You ain't gonna have to wait much longer, man. Oh, yeah. My music math is off. This is the beginning, though. Come on. Come on, give me the gavel. Ladies and gentlemen, welcome to the first weekly installment of Manic Monday, featuring Judge Alex Manning from the gallery live. I've picked out some pretty interesting cases, I believe, and I've curated them as I always do, and I've put them together in a little 1-hour package where we can all sit together and enjoy them and chat about it. I'm not gonna talk it up too much because it's Judge Manning, and how much is there to really say other than, come on, let's get started, shall we?
All right, position 5, we got 24 PI 000679 Nicholas Fertic, 158 days without indictment as of April 26th. There is a $50,000 good bond, aggravated assault not resulting in serious bodily injury, armed robbery, and possession of a firearm during the commission of a felony. So, Ms. Jackson, it's 20,000, 20,000, and 10,000.
8 arrests in Georgia, arrests in South Carolina. In South Carolina, there's a prior armed robbery, burglary with a weapon in 2014, common law robbery in 2012, burglary in 2013, firearm during firearm buy. In Georgia, there's 8 cycles. There's a battery, family violence, cruelty in the 3rd, and criminal trespass damage in 22, FTA in 22. Nothing further.
All right. Go ahead, Ms. Strong.
Thank you, Your Honor. Mr. Fertic is 32 years old. He has been living in Atlanta for the past 3 years. He was living at the incident location at the time, However, he is going to be moving back to Orangeburg, South Carolina, and I do have a good address there, where he will reside with his mother. He was working for DoorDash, and he also owns his own company. It's an agency that he does contract work for a few social media platforms. However, due to the fact that he's been in custody for 157 days, he's in the process of that business being dissolved since he's not able to operate it while he's in custody. Mr. Fertic has no issues staying away from the complaining witness, but it's Ms. Guest's understanding that she was in favor of him receiving a bond reduction tonight. He's lost a lot, including his business, which was his sole source of income since being in custody. So we're asking for a reduction tonight of $5,000 on count 1, $10,000 on count 2, and $5,000 on count 3 for a total bond of $20,000.
All right, go ahead, Ms. Jackson.
Judge, I think based off of the history that Ms. Bosick just provided to us, the fact that Mr. Fertic has armed robberies in both Georgia and additional states, has battery, family violences, has multiple firearm charges and multiple robbery charges. I think that history highlights that Mr. Fertic is a danger to the community and likely to reoffend. It also appears that Mr. Fertic has multiple failure to appears. In this case alone, when he spotted the officers, he took flight and began to run past the wood line near an event that was being held for children in celebration of Halloween. The officers were unable to catch the suspect at that time. However, the victim in this case did inform the officers that after Mr. Fertic came home angry and upset with her, he actually held a gun to her head while her child was in the home and told her that either, quote, they were either going to fight or fuck that night. Judge, Mr. Fertic is a complete danger to the community, and whether or not the victim in this case believes that a bond could be granted by the court, there's nothing that shows that Mr. Fertic is not a danger to that victim under these circumstances. For that reason, we believe that a $20,000 bond on an aggravated assault, a $20,000 bond on an armed robbery, and a $10,000 bond on a firearm during the commission of those felonies, especially considering he should have been charged with firearm by a convicted felon based off the history that we just heard from Ms. Bostic. I believe that that's an appropriate bond, and the only thing that could potentially give this court any power to keep Mr. Fertic from reoffending or hurting the community and this victim in the future.
All right, no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away from 1212 Utoy, UTOY Springs Drive in South Fulton. Stay out of Fulton County. The only reason you come back to Fulton County, sir, is court or to see your lawyer. You do not darken the doors of the county of Fulton for any other reason. No further contact with Tyreque Walden, Tyreque, Walden, WALDON. Also, sir, you're going to have a 24-hour curfew. If the county has the funds, you'll have an ankle monitor. Even without that ankle monitor, you'll have that 24-hour curfew. Court, lawyer, medical, and employment. You have to supply the name of your employer, proof of employment, schedule, and the exact location you'll be working. 15,000, 15,000, and 10,000. Best of luck to you, sir. Thank you, at South Annex. All right, now I've got Antonio Jones. All right, Mr. Jones is position 6, Bostic 24 PI 001297. There's a $10,000 good bond as of March the 18th, 132 days without indictment, theft by receiving stolen property, and possession of a firearm during the commission of a felony. That's 5,000 and 5,000. Wow.
6 cycles, no dispositions, or either dismiss, or every cycle on his GCIC, no conviction shown on his GCIC. Nothing further.
All right. Go ahead, Mr. Strong.
Mr. Jones is 21 years old, born and raised here in Atlanta, has a lot of family in the area. He's a high school grad and was working as a valet at the Holiday Inn in downtown Atlanta at the time of his arrest. He also has a side business doing pressure washing. He has a good address. It is in Fulton County at 3144 MLK Junior Drive. It's an apartment where he lives with his mother, Shadaria Jones. I've been in contact with his mother many times over the course of his incarceration. She's very invested in him and his success when he bonds out. At this time, he cannot afford the bond as set. We are asking for a reduction in bond to the amount of $4,000 on both charges.
Go ahead, Ms. Jackson.
Judge, in light of the fact that Ms. Bostic says that even though he has 6 cycles, there's no dispositions, the state would not object to a bond of $25,000 on the theft by receiving stolen property and $25,000 on the possession of a firearm during a felony.
So it's 10,000 right now.
Right, 2,500 on each.
25. Okay, I thought you said 25,000. I was like, ooh, okay. All right, so we got no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away from 37 Lyndhurst Drive in Atlanta, Georgia. No further contact with your co-defendant, Crystal Upshaw. So I'll do 2,500 and 2,500. Best of luck to you, sir. You can leave the booth. And I'm emailing the state about like everything that I have and not just the ones over so many days. That way they can keep up with it. All right. All right, Mr. Woods. Position 2, Bostic 24, PI 002275, 94 days without indictment, no bond as of April the 1st on 1 count of aggravated stalking. Rah.
Only Georgia arrest on his GCIC is 24 CR 001527F, violation of a family violence order, but he also has 23 CP 221774 ag stalking, 8 cycles. Another state, I did not write down which state, but his convictions there are old. One is 20 plus for drugs, and the other one is about 15 for cocaine. Nothing further.
All right, Ms. Dorsey Jones, is there any contact with the victim? I'm sure Mr. Cazzoli's going to ask.
Yes, that's position number 2, correct, right?
Uh-huh.
Yes, she said that she's not opposed to bond.
All right, go ahead, Mr. Cazzoli.
Thank you, Your Honor, and good evening. Your Honor, Mr. Woods is 59 years old. His most recent address when he was incarcerated was an apartment at 1476 Steam Engine Way, Northeast, Conyers, Georgia, 30013. He'd been living there for 18 months before his incarceration. Since then, he has been able to secure housing to live with his brother, who lives in the area. I have not been able to confirm an exact address yet, but that address would be provided before he is released. Mr. Woods is a high school graduate. He also attended trade school and received an HVAC certificate. He has a good job working at Shoemate Mechanics in Duluth, Georgia. He has 2 adult children, 6 grandchildren. Your Honor, he has no issue with a no contact order, no issue with a stay away order. Your Honor, we're asking for a $10,000 bond. First, Mr. Woods is entitled to a bond, having been incarcerated for longer than 90 days. And 2, Your Honor, as the victim advocate provided, the alleged victim in the case has no issue with Mr. Woods receiving a bond. We understand that the allegation is what it is, but it is he does have relatively limited history in his 59 years of life.
All right, go ahead, Ms. Jackson.
Judge, I believe the nature of these charges kind of speaks for itself, especially since Ms. Bossick just illustrated that Mr. Woods has an open case of aggravated stalking. A lot of our system was down before court started, so I wasn't able to see if that is the same victim. However, Mr. Woods is clearly a danger to the victim in this case. While I do understand that the victim says she's not opposed to bond, as Mr. Cazzoli stated, he's entitled to one. But we do believe, the state does believe that it should be one that can protect the victim and the community in this situation. Mr. Woods is likely to reoffend, considering he has an open case for aggravated stalking and picked up another case for aggravated stalking. The facts in this case on the warrant state that the officer actually watched the video and observed Mr. Woods violating the TPO. And I do believe there's been a preliminary hearing where the facts of this case have been established. And so, Judge, in order to keep the community safe and the victim safe in this case, we do believe that a bond of $80,000 is reasonable and appropriate.
All right, Mr. Woods, I need a thumbs up or a thumbs down. Are you going to live in Fulton County? Nope, that wasn't a thumbs down, but that was a head shake of no. Okay. All right, no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay out of Fulton County. The only reason you darken the doors of Fulton County is to court or to see your lawyer. You do not come back to Fulton County. No further contact with Nancy Bellinger, Bellinger. Stay away from 7145 Cavender Drive Southwest. Also, if it's available, you're going to have an ankle monitor paid for by the county. If it's not available, you still have a 24-hour curfew. Court, lawyer, medical, employment. Those are the only reasons you leave your house, sir. The only reasons you leave your house. 25,000. Best of luck to you, sir. All right, let's see. All right, so when I call your name, wait in Cobb. I don't know who you are. Are you Greg Swinson? Nod your head or something. You are? Okay. She's a victim in which case?
It's gonna be for position 11.
Okay, can she make her screen name her first and last name? What's her name?
Her name is, I can't remember her first name. Her last name is Riley. She should be
Tipanica.
Okay,
Tiffany. Tiffany
All right.
Riley.
all right, so Bostic, this is number 7, 24 PI 001305, Gregory Swinson, 131 days without indictment. $16,000 good bond as of March the 18th. Theft by receiving stolen property, receipt, possession, transport of a firearm by a convicted felon or felony first offender, etc. Possession of a firearm during the commission of its felonies and marijuana less than an ounce and fleeing, attempting to elude. Wow.
Judge defendant is currently on 3 separate probations. On probation in McDuffie for burglary 1/12/22, 8 years confinement and theft by receiving, 5 years confinement, 8 years probation. Kelly O'Farrell 1/12/22, 5/2, sentenced in 2015, theft by receiving and burglary. Green for burglary, sentenced in 2019, 5 years confinement, 15 years probation. Prior criminal attempted burglary in 2016, firearm by a first offender, carrying a concealed weapon in a school safety zone in 2016, theft by taking in 2016. Nothing further.
All right, go ahead, Ms. Strong.
Thank you, Your Honor. Mr. Swinson is 26 years old. He's born and raised here in Atlanta. He lives at the Edgewood Apartments at 200 Edgewood with his sister. And at the time of his arrest, he was operating a t-shirt business. All of his family is here in Atlanta. He is currently on some medication for an injury he received after being shot. He's been in for quite some time, 131 days now, and cannot afford any bond in this case. However, we're asking for a reduction today to the amount of $8,000 on these charges.
All right, go ahead, Ms. Jackson.
Judge, again, I believe the history summary from Ms. Bostic speaks for itself. Mr. Swinson has picked up very serious charges and has been convicted of those charges multiple times since 2016, multiple counts of burglary, multiple counts of theft by receiving, all that align with the facts of the case that's before you today. There's no doubt that Mr. Swinson is likely to reoffend and is a danger to this community. Based off the FTAs and his history, the state's position would be that he's also a flight risk. For that reason, we believe that the bond that is set, the $16,000, is more than appropriate and reasonable with his history. So the state will request that the bond be left at $5,000 on the theft by receiving stolen property, $5,000 on the firearm by a convicted felon, $5,000 on the firearm during the commission of a crime. No objection to keeping the UJR on the marijuana, and $1,000 on the fleeing and attempting to elude.
All right, no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away from 1991 Martin Luther King Jr. Drive. No further contact with Larry Moore, Moore. Let's see. I'll get 4,000, 5,000, 5,000 UJR and 500. 4,000, 5,000, 5,000 UJR and 500. Best of luck to you, sir. Let's see. Are you Mr. Wilburn? Wave, nod your head, give me a thumbs up, give me something. All right, is Mr. Showalter not coming?
Your Honor, Attorney Cazzoli is I'll be covering for Mr. Showalter tonight for both positions.
Okay, outstanding. Position 9, 24 PI 001573. Reginald Wilburn, 121 days without indictment, $15,000 good bond as of April the 24th for burglary in the second degree. Rah.
In regards to Mr. Wilburn, 41 cycles, FTA and 21. On probation, theft by receiving misrepresentation of tag from 9/27/19, 1 year confinement, 4 years probation. Then there's open 24 SC 002432, burglary in the second degree, then 22 CP 211390, burglary, 2 counts, and tools, history, probation violation, nothing further.
All right, go ahead, Mr. Cazzoli.
Thank you, Your Honor. Mr. Wilburn is 45 years old. He's 45 years old. He has a good address at 5401 Old National Highway, College Park, apartment 1413. He lives there with his mother. His whole family is from Atlanta. He has been living in Georgia his entire life and been in the metro area for the last 15 years. I'm sorry, Your Honor. He also he does have a job. He does landscaping with his uncle, and he has a 15-year-old child. His bond was set at $15,000 back in April. We are now asking for that bond to be reduced to $5,000.
All right, go ahead, Ms. Jackson.
Judge, I believe the history in this case speaks for itself. Mr. Wilburn is extremely likely to reoffend, and is a danger to the community based off the history. The state would agree and consent to a bond of $10,000.
All right, no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away from 5415 Old National Highway, and that's close to where you live, so don't even drive in the direction of that incident location. $10,000 good bond. Best of luck to you, sir. You can leave the booth. If you can send in Mr. Barnes. All right, Ms. Safarasi. This is position 11, Bostic 24, PI 001578, Tariq Jamal Barnes. 40. Wait, what is this? This is $25,000 good bond as of April the 25th. Wait, hold on a second. It's more, that's the, okay, here's the thing. Ms. Jackson, that's all I have on here. Some of it says released on original bond, released on, and I don't know what that bond is. I couldn't find that bond order.
I can explain it, Judge.
All right, so it's cruelty in the first, battery, 2 counts of cruelty in the third, and 1 count of criminal trespass.
Judge, it's only going to be cruelty in the first 1 count. One of the cruelties was dismissed at a preliminary hearing. Those other charges that you named out, he already posted bond on. That's why it says released on original bond for those charges.
Okay.
He's already paid bond. It's a separate case. They duplicated it. I try to get it all dismissed, but they've just put it as release on original bond.
All right, go ahead.
So Mr. Barnes, Judge, he's been in 120 days. How this case derived is the complaining witness is his ex-girlfriend's son. This incident actually happened about 6 or 7 months before his arrest. The girlfriend did not report it to police before then. The only reason she's reported this incident is after that they broke up and got into an incident. Then she reported him for this particular case. So what happened was there was an incident and he bonded out on those charges. And then she reported him for this incident that happened about 6 months prior to his arrest. And then they no bonded him, Judge. We went to prelim. They dismissed it. It's 1 count. The allegation is that essentially he was disciplining the child with a belt. And so the allegation is that it went too far, essentially. Our defense is that that's not quite what happened, and that's really that the mom is creating a bigger mess for him. And that's just a little context about what's going on for Mr. Barnes. Like I said, Judge, he's been in 120 days. He can't afford this bond. And the state is not moving on this case. We do have a good address for him here in Georgia, and he can stay away from the incident location as well as the complaining witness and his mom. He does not have contact with them. He has no reason to have contact with them, and he does not want contact, Judge. So in terms of likelihood of reoffend or intimidating witnesses, we do not have that here. This is an isolated incident. And so, Judge, because of that, I'm asking for a reduction to not exceed $7,000 total.
All right, so is he going to live in Fulton County?
Yes, Judge.
All right, go ahead, Ms. Jackson.
Judge, I may have missed it, but did Ms.
Oh, I'm
Bostic-
sorry. Do you want to hear from Ms. Riley? Ms. Riley, if you take yourself off mute, if you can raise your right hand, ma'am. You swear affirm testimony you're about to give. There you go, your military right. You swear affirm testimony you're about to give is the truth, whole truth, nothing but the truth. I can't hear you.
We
Yeah, still
can't.
can't.
Riley.
So, Ms. Riley, you may have to connect to a different audio. If you're going through Bluetooth, it may not be working, but while you're trying to work that out, I'll hear from Ms. Jackson.
And Judge.
Can you hear me, ma'am?
All right, I can hear you now. Go ahead. I just want to know your position on bond.
Hold on. Repeat that for me, ma'am. Hold on. I might. Come on.
All right.
Can you hear me better?
Yes, I just need to know your position on bond and having contact.
Absolutely not, ma'am. The
See-
issue is that there was a case in Cobb. He was released on bond approximately a month after he offended. It was against my 5-week-old baby at the time. And
So I know that Ms. Safarasi is going to object. So the cop, I just need to know about, you don't want any contact, right?
Judge, yeah, this isn't a preliminary hearing. You were very specific on what, and also he's entitled to a bond. And he has.
I'm having a hard time hearing you.
All right, why don't you
And
just,
hold
why don't
on,
you
give
just,
me
why don't,
one
no,
moment.
why don't you, oh,
There we go. That's much better.
all right, Ms. Riley, why don't you listen? Let me hear. I'm gonna put you back on mute and let me hear from Ms. Jackson. Go ahead, Ms. Jackson.
Judge, did I miss Ms. Bostick going over Mr. Barnes' criminal history?
Hmm?
He skipped me.
Oh,
Okay, we would need to hear that, because it's extremely.
wow. See, she don't even speak when I do that.
Miss Safarasi started talking first, Judge,
Well,
to get that information correct.
Boss,
he
you
has-
gotta blame me.
He has 4 cycles. He's on probation out of call for simple assault, battery, cruelty sentence earlier this year for 12 months. Out of New York, there's 7 cycles. There's a criminal possession of a weapon, and then 2 old felonies for a couple for robbery and criminal sale. Nothing further.
all right. Go ahead, Ms. Jackson.
Judge, I did speak to Ms. Riley before court started today, and she did have a lot of information about prior incidences with them. Ms. Safarasi's indication that Ms. Riley is just someone trying to make a big deal out of this case is actually extremely disheartening. Mr. Barnes is alleged to have beat a 9-year-old so bad that they peed on themselves and was unable to sit in school the following day. The case in Cobb County, as Ms. Riley just said, is a case against a 5-year-old baby.
Judge, I have to object to this case with Cobb County. We're not here for Cobb County. He is sentenced, it's done.
Actually,
we need to
he
stop bringing up.
agreed.
Hold on,
Actually, he agreed
objection
at
to
the
Ms. Riley speaking whatever she's about to say, Judge. Objection to everything. We're not here for Cobb County. We're here for this one case in Fulton County. Can we please focus in on what we're here and what is before the court? The court is here not to talk about Cobb County. We are not in Cobb County. We are in Fulton County.
Judge, I'm extremely alarmed that Ms. Safarasi is putting up such a fight to bring in this person's criminal history, which we put on the record on every single case. Again,
to get into the facts of that allegation, Judge, I'm objecting. We have the conviction. We understand there's a conviction, a prior history. We don't need to.
Hold on. Y'all are about to make Miss Jones mad, which is 10,000 worse than making me mad. One at a time.
And if it's Ms. Safarasi's time to speak, then the state is happy to wait. But if Ms. Safarasi can hold on while victims speak and while the state speaks, then I think that would be the proper court decorum.
I'll let you respond.
I will make my objection when I see fit.
Go ahead, Ms. Jackson.
Okay, and I'm going to continue to speak. As I stated, he has a criminal history that is extremely relevant because it is identical to the facts in this case. In Cobb County, he has a case where he slapped or battered or assaulted a 5-week-old baby. So your indication that this has never happened, that this is some type of one-off that would never occur is inaccurate. And the state has a right to respond to that. As you see, Ms. Riley has appeared today because she is extremely afraid for her and her children's life. And so if you think that the state is going to sit here and let you make a mockery of this court and of this victim because you don't think it's a big deal, then you are absolutely incorrect. Mr. Barnes has an extremely dangerous history. He committed these crimes. He has open cases. He has a probation case, all of which the victims are the children of Ms. Riley. If Ms. Safarasi thinks that's not important, then that will be for the court to discern. But as for the state, that is a very extremely dangerous person, and he is a danger to the victims in this case. He was a danger in Cobb County. He's a danger in Fulton County, and he deserves a bond that is reasonable under the facts of this case and the history that he has for himself. That is a conviction, not an allegation, as you like to normally say, Ms. Safarasi. He was convicted of assaulting a 5-week-old baby. So that is relevant to this case.
Judge, objection. The case before you is not about this 5-week-old child. That is not what's before you. It's about a 9-year-old that had happened allegedly 6 months that she failed to report until this alleged Cobb case had happened, Judge.
Hold up. Ms. Jones, you need to take yourself off mute and yell at him.
Judge.
Yes, ma'am.
Which Jones?
Hey, y'all.
Tiffany Jones.
Yes, I really need everyone to speak one at a time. Honestly,
You don't even sound that mad, Miss Jones.
I know it may be. Listen. It's being recorded.
All right. So, if you're finished, anything else, Ms. Safarasi?
Yes, Judge. Again, like I said, this is not what we're here before. If this case was so important to the state as she wants to make it believe, why is he sitting 120 days without an indictment? Where is the state moving on this case, Judge? He has a bond. He is entitled to a bond. We are here because he cannot bond out, and the state is not respecting his rights as well. These are allegations. What is before you today, Judge, is an allegation. That is not a conviction. I understand we want to keep referencing this Cobb County case. Fine, that is a conviction. You can take that into consideration as a conviction, Judge. But in terms of what is before you, that is just trying to murky the water of what is before you, Judge. This is a case
Gotcha.
not involving that child, Judge. And also, we can rectify all of this by the state indicting this case and moving forward so we can have our day in court, or B, you can have a stay away, no contact. Judge, my client does not object. He has no reason to have contact. So there's no reason
I
why
got it.
anybody involved in this case should be afraid.
Stop. All right, Miss Alfrossi, I got it. What else, Miss Riley? What else?
I feel like I'm not being heard, Your Honor,
no, no.
and it's really regarding me and my 4 children. When you've been abused for years by the same individual, you don't report things right away because you're fearing for your life. My son is in the vehicle right now. If you would like to speak to him about the abuse, then you are more than free to do so. He is in fear of his life. I am in fear of my life. My daughters are in fear of their life. We look over our shoulder everywhere we go. He has been released on bail, and he has definitely repeated. As a matter of fact, when he was released on bond the last time, he was out on bond for 3 years, and he did worse things than he did the first time he was released on bond. This time, the abuse not transferred only to me, and to my newborn baby, it transferred to my oldest son. And my son is the sweetest child. He makes straight A's, and he has known this child since he was 2 years old. And so he has a hatred for us, and he has reoffended several times, and I have forgiven several times. But it's like when you let them out on bond, who knows how long this case is going to go back into court for it to be defended. And then at worst, we could be dead by that time. And so I'm really depending on you guys today to make a right decision based on the criminal history that he has had in the past, violent history, and he has pled guilty to the one in Cobb. And you say it doesn't matter, but he violated his bail the last time. The bail was violated last time, and he still left without any charges, and he still left with no jail time. He still left with just probation. And so now we're giving him a slap on the wrist every single time, and there's no comfort and no security for me and my children's safety. And she's saying let's forget about Cobb. Tell these children to forget about Cobb. Tell me every time I've lost my home trying to escape this man, tell me to forget about Cobb. Tell my daughters who have lost their dad and seen them abuse me, tell them to forget about Cobb, because that's ridiculous. And then tell them to forget about in Fulton County when they had to see their brother be abused and recover from being beat on and being scared to death, locking themselves in the room and then double locking themselves in the closet. You tell them to forget. Tell those children to forget the trauma that they've experienced by the hands of this man, by hearing me getting beat through the walls. Tell those children to forget every single memory that they have of me getting dragged by my hair in the kitchen, getting sliced across my forehead by a knife, and tell me that he's not going to reoffend. And then when he reoffends, put the blood on your hands.
Okay. All right. Thank you, ma'am. And I don't know what they did in Cobb, but this ain't in Cobb County. All right, so we got no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. If it's available, you're going to have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, and medical, the only reason you leave your house, and report to probation if that's what you've got in Cobb County. No further contact with Benjamin Tate Riley, Tiffany Riley, let's see, Ayana Riley, or any other children. Let's see. As a matter of fact, stay away from all children unless they're your relatives, but none of her children, none of their children, nobody else's children. Stay away from 531 Carlton Point Drive in Palmetto, Georgia. Also, I think I already said no drugs, no alcohol, no weapons. Even if that ankle monitor is not available, sir, you will have a 24-hour curfew. Those are the only reasons you can leave. I'm leaving it at 25,000. Best of luck to you, sir. 24 PI 003656 Rodney McWay.
And we would,
All right, I'm gonna pause here just for a second. And just kind of take a break. That was heavy. That was a super heavy case. Those were all from July 3rd. This is a new docket that we're coming into right now. This is actually from the 26th. This is actually a really interesting and notable docket in and of the fact that the court has been having some technical problems in the hearings previous to this. So they have a particular case that they've been trying to get taken care of over and over and over again. And because of one technical problem or another, it keeps getting pushed off. And the guy has been sitting and marinating in jail for like 400 plus days. I'll let you see what the charge are. We'll get there fairly quickly, but I think it's kind of cool. I'm an IT guy. I think it's kind of cool how Manning kind of puts on her IT shoes in this docket. So let's check it out.
24 PI 003656 Rodney McWay.
And we would ask to waive sounding on anything recent.
Oh, okay. All right. So Rodney McWay, 218 days without indictment, is no bond as of May 24th. Ag assault, possession of dangerous weapon, and riot in a penal institution.
15 cycles. He has an open capital offense, 24 SC 000971. A 2016 unauthorized use of a vehicle conviction, 2015 grand larceny conviction out of Virginia, and then a 2014 unlawful entry conviction out of DC, and nothing further.
All right, go ahead, Ms. Strong.
Thank you, Your Honor. Mr. McWay is 32 years old. He's originally from Washington, D.C., but has been here since 2020. He's been incarcerated for the last 7 months on the open case that pretrial mentioned. So currently, I cannot provide an address as he will be remaining in regardless of the outcome of tonight's hearing. He graduated high school back in Washington, D.C., and at the time of his arrest, he was working in the housekeeping department at Six Flags over on 20 West. Prior to that, he had a career where he worked at U-Haul. He has 3 children. We had a preliminary hearing for this charge the other day. Probable cause was found. However, Mr. McWay was the only person injured in this incident. So we are asking for a total bond of $20,000 on these 3 charges.
It still had no bond then, but no one set a bond.
We did not address bond at his prelim.
Okay, go ahead, Mr. White.
Judge, as was pointed out, this isn't what's holding him in, and I think what is the incident date on this?
May 23rd, I think.
Yeah. I mean, we're not even approaching 90 days, given the fact that he has 2 prior felonies from Virginia, 1 prior felony from Washington, D.C., and he's facing a capital offense here. He is a significant danger to any community in which he finds himself. He is a very real danger of reoffending, as he has tenuous at best ties to Georgia and to the metropolitan area. There is a very significant risk that he will not appear if and when released from confinement, if that is prior to his trial. Judge, the state is opposed to any bond on these charges at this time. Nothing further.
All right, since he's, instead of bringing him back and the capital case is obviously holding him, we'll go ahead and set it. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Once he gets out, he's got to provide an address where he'll live, and he'll have a 24-hour curfew. Only reason he can leave his house is court, lawyer, medical, and no further contact with, I'm not sure how to pronounce this young man's first name. It's Durricor. Last name is Humphrey, Humprey. So I'll do 20,000, 10,000, and 5,000. Best of luck to you, sir. All right, let's see. So we'll take care of Mr. Shokley.
Excuse me, this is Deputy Walker. 7 North said they needed someone to turn the camera on.
He needs to go to booth 3.
Booth 3?
Yeah,
Okay.
it's on. I'm looking at it.
So booth 3 is on.
Yep, we're
Okay.
looking at it.
Okay, all right, let me call back over there.
All right, no worries.
Okay.
All right, we got Gregory Shokley. It's 24 PI 002725, 100 days without indictment. There was a consent bond of $12,000 in May 10th, 2024. We got possession of cocaine with intent to distribute, allegedly 60 grams, possession of a firearm or a knife during the commission of a felony, possession of a firearm by a convicted felon, marijuana less than an ounce, possession of drug-related objects, receipt, possession, transport of a firearm by a convicted felon or felony first offender. Rah.
33 cycles, 2020 conviction for possession of a firearm by a convicted felon and sale of marijuana, a 2019 conviction for sale of marijuana, a 2016 conviction for possession of a controlled substance and possession of a controlled substance with intent to distribute, a 2010 conviction for sale of marijuana, 2004 conviction for possession of a controlled substance and sale of a controlled substance, and then a 2001 conviction for robbery, and nothing further.
All right, go ahead, Ms. Strong.
Thank you. Mr. Shokley is 46 years old. His residence is at 1905 Idlewood Drive in East Point, Georgia, in Fulton County. He's born and raised and been here his entire life. He's a high school graduate and received an associate's degree from Atlanta Tech in business administration. He was previously working as a music engineer. We are asking for a reduction in bond, the amount of $6,000 on these charges.
All right, go ahead, Mr. White.
Judge, he already has a consent bond, and I've heard nothing to say that that consent bond was unjust, unreasonable, or that there's been any change in circumstance at all, any reason at all to modify that consent bond, especially given the fact that this defendant has 6 prior convictions, all of which are to one degree or another similar to the charges that he is now facing. I don't want to say it's a certainty, but it's a certainty that he will reoffend almost as soon as he's released on from confinement, which he eventually will be. Judge, we're just waiting for a confirmation as to whether this is in fact trafficking weight and what exactly the substance is before it's indicted. The state will point out that this is a April 2024 arrest. Therefore, by my calculations, the state has about 1,430 days to indict it remaining before there's any issue as to whether the indictment is untimely, given the fact that this defendant has a bond. Also, given the fact that this defendant has a bond, the state has about, 9 months? April, May, June, July? Yeah, about 9 months before there's even any presumption that the defense is in any way prejudiced from the fact that this defendant is in confinement. Your Honor, there is no reason in law or fact to modify the bond, and this defendant's record, the likelihood that he will reoffend, the dangerousness that he presents to the community, all mitigate against any bond at all, much less a reduction in the already very, very generous bond, which was agreed to by his defense counsel, nothing further.
All right, no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away from 901 Joseph E. Boone Boulevard Northwest. I mean, conditions on here, so I'll leave the ones that are UJR, because that was a consent. So the 3 counts that are 4,000, I'll make them 3,000 apiece. Best of luck to you, sir. You could lay the booth.
Okay, can you all hear me?
Yes, ma'am.
Okay, the deputy said that camera is turned facing the
All right, so which one?
attorney's booth.
Which
So
one
we
do you want us
he
to
said
open?
that he has the inmate, but he needs the camera on in booth 2.
Booth 2. Okay,
Yeah.
all right. Oh,
What
invite
y'all
it.
looking at is the
All right, take
attorney
care.
booth. Okay.
Sorry, Miss Lake, of course. Let's see. 2.
Judge, you want to try 7 North Booth 1?
Well, I can't, I'm trying to. Wait, if you can get your Zoom controller, if you just turn on that camera. Cannot be happening. Cannot be happening. Sure it can, Alex. I'm gonna scream.
Don't do that, Judge.
Oh. Seriously? Come on now.
Not connected.
Yeah, Judge, I talked to IT about this Tuesday and yesterday, This is not an us issue, like I was telling you the other day. It has something to do with some updates and some licenses and something else. I don't know. But I thought they looked at it between Tuesday and Wednesday.
Right.
So they're
Well,
aware.
Well, that's the thing is that my Zoom controller's not open again, and I used it today because I had an inmate calendar.
Mm.
Oh dear God in heaven. I'm trying, Miss Lake. God almighty.
Not a problem, Judge. I'm not in a hurry.
Hold on, let's see. See, I shouldn't have said it was gonna be, let's see. I'm calling somebody from. Is it letting you open it, Mr. Dukes?
No, still say contact IT.
All right, let me, hold on one second. Hey, LT, so at Bogle, are those cameras inside?
I think Judge lost connection, so we'll have to wait for her to log back on.
Only with Miss Lake and me and this one client. LT, Bogle, can you turn the camera around in booth 3 by any chance?
I don't have access to it. I think you need a key to get into that door.
Okay, stand by. Let me try again.
And it's on the opposite side of where I'm at. It's like on the back side.
Okay. Tom just said it could be a network error, which, of course.
Let me see if I need a key to get in there.
Okay, hold on.
From the
Hold
opposite
on.
side.
Your Honor.
Yes.
I'm talking to the IT guy that works for jail. He said that he has a key, he has to know where the key is to open that up. He will have to, it'll take him about 10 minutes to come back to the jail.
Bogle, do you know where the key is?
I don't.
Okay, I mean, the man needs to, he's been in 451 days, yeah. Just tell him to, like, quick like a bunny.
Yeah, she said, come on.
I said, quick like a bunny.
He said, quick like a bunny. Okay, all right, thank you.
I was
He said he's on his way.
Okay.
Okay. So he'll go up there and open it.
Yeah, so just tell the guy to go to booth 3. He'll go up there and open it and do whatever. I'm sorry.
Thank you. Sorry about that.
Yeah, no, that's okay. Tanja just said it was the network error, but I'm like, oh. She says it's raining. I said, but yeah, I mean, come on now. It just worked. I was working the other day because I had inmate cases. Ugh.
Oh, buddy. If he says he's going up there, this time.
Mr. Dukes, you're the one that said it's 3 cases, Judge. It's gonna go quick. Or was that me?
No, I think that was you, Judge.
So he is gonna go up there and open it and turn the camera around.
That's what she said. Take him 10 minutes.
Okay, well, have a good evening.
Hey, what, Bogle? Hold on, you ain't excused yet, Bogle. You need to tell him to go to booth 3. If he's not in booth 3, he needs to go to. Somebody needs to tell him. I couldn't tell which way. I just know the camera's working. I couldn't tell which way it was facing because I'm still trying to get it on. Get the Zoom controller. It's still just no luck for you, Miss Lewis.
All right, I'm gonna go up here and tell him just
this
I got in booth 3.
No luck, Judge. And I can't even access it from the Zoom itself because the jail is not connected to my Zoom through the regular Zoom.
Come on, today, guys, today. Come on, come on, come on, come on, come on. Thank y'all for being patient. Wait a minute. Come on. I was pulling up slowly. Retry. Give me a break. Time to go into booth 1. Come on, got it. Come on. Look at that. Boom.
Got it.
I can figure something out sooner or later. Thank you, sir. I'm sorry about last week. Thanks, Bogle. Sorry about this week. That's just so no one else. All right. Last one. All right, so it's a Nolan Lipsy, 23 CP 222854, 451 days without indictment. That was a $33,000 good bond as of May the 3rd, 2024. We got aggravated battery, possession of a firearm during the commission of a felony, unauthorized possession of prohibited item by an inmate, ag assault, and riot in a penal institution.
9 Cycles, a 2019 conviction for aggravated assault and possession of a firearm during the commission of a felony. 2006 forgery conviction, 2006 possession of a controlled substance, and nothing further.
All right, go ahead, Slate.
Thank you, Judge. Your Honor, Mr. Lipsy is 37 years old. He was born here in Atlanta. He's lived here his whole life. Before his arrest, he was living with his fiancee, Shanice Baker, at 516 Boulevard Northeast. Your Honor, he was working as for a car detailing service. And I don't mention this because I know we're not considering the Ayala factors. Mr. Lipsy has already been determined to be eligible for a bond. And so we're actually looking at OCGA 17-6-1, subsection E, subsection 2, subsections A through D. And so under that code section, the court has to consider his financial resources, his income, his financial obligations, and the purpose of setting bail. And Your Honor, we're asking the court to reduce bond to $1 on each charge. And I'll go through those factors and explain my reasoning to the court. First of all, as to financial resources, working for a car detailing service, Mr. Lipsy was working for an hourly wage. He's been in custody now well over a year, and he has no financial resources. Neither he nor his family do. I've spoken with his mother, I've spoken with his sister, I've spoken with his fiance, and they are not able to afford a bond for Mr. Lipsy. He does not have an income. He has not had an income for over a year. And he does have significant financial obligations. So anything that he did have saved up before his arrest have gone to support his 4 children. Your Honor, he has a 14-year-old daughter, Shokley, who is in high school, a daughter, Chloe, who goes to, middle school in Riverdale. He also has 2 sons, Avery, who's now 9 years old. He goes to elementary school in Morrow, Georgia. He plays baseball. And Levi is his youngest son. He is 6 years old. Before his arrest, Mr. Lipsy had his children regularly. They stayed over with him at night. And so his family has really struggled to support the 4 of his children, and his resources are long gone. They have gone to support his children who are now struggling without his help. And finally, Judge, will just mention subsection D, the purpose of bail. The purpose of bail is not to keep Mr. Lipsy in indefinitely. We have, in fact, we've tried to make it easy for the state to move this case along. Over a week ago, we filed a waiver of indictment so that the state could go ahead and accuse it, and we could move this case forward. But the purpose of bond is not to hold him in custody while we're waiting for the state to bring formal charges. The primary purpose of bond, as we know from Ayala, is simply to ensure that Mr. Lipsy returns to court when called upon to do so. Your Honor, he certainly can't make the $33,000 bond. I submit that a $1 bond on each charge, or at least a nominal bond of maybe $50 on each charge, will be plenty to ensure that somebody who is struggling to support himself financially and to support his kids when he's in the community, let alone in jail for over a year, is enough to incentivize him to come back to court. I'll point out, Judge, that at the preliminary hearing in this case, we heard that the complaining witness, Tyrance Bernard, was struck in the face twice. I don't believe there was any evidence of serious injury, so I don't think that this is an aggravated battery. This is there was allegedly a shank involved, but there was never a shank recovered. So again, Judge, Mr. Lipsy is eager to get the show on the road, to get this case formally charged and resolved, and to answer for those charges. We have asked for the state's help in doing that, and now we're asking for the court's help in allowing him an opportunity to go back to his children while we're waiting.
All right, Mr. White.
Judge, as the court is aware, there are in fact 4 purposes to bond as outlined in OCGA 17-6-1E, and that the factors quoted by defense counsel are in fact factors that go to the initial setting of bond. And after that, then the question becomes for modifying bond, what has significantly changed, and is the defendant eventually, and I note that in this case there is a constitutional speedy trial prematurely filed, eventually the question will become, has the defense, interestingly enough, not the defendant, but the defense been prejudiced by the amount of time in jail? There's an additional 89 days before there's even any presumption of prejudice that can attach in this case. So we are at least that much premature in this discussion at this case. In addition to that, by my calculation, now that Mr. Lipsy has a bond, the state has 1,217 days in which to indict this before actually then we reach the point where there's enough prejudice that then a conversation about dismissal is appropriate. In this case, conversation about modification is premature, conversation about prejudice is premature, conversation about really anything is premature, and there's been absolutely no showing that anything has changed from the $33,000, from the time that $33,000 was set until today. Judge, there is no basis for lowering the bond, much less giving Mr. Lipsy a get out of jail free card. That's certainly not the intent or the purpose of bond. State will also note that Mr. Lipsy has a 2005 felony conviction in addition to the 2019 felony conviction for a violent felony that was noted by pretrial. In addition, Mr. Lipsy was in jail at the time of this offense on 23 SC 188224, which I believe Mr. Lipsy ordered entered a guilty plea to a reduced charge on, I think it was May 6th or May 7th of 2024, for 12 months confinement and an additional 12 months probation on a family violence battery, and a cruelty to children in the 3rd degree, although that, yes, he also pled to that. One of the children that he allegedly cares for. Judge, the state is opposed to any reduction in the bond at this case, there being no showing that there is any basis in law or fact for reducing the bond, and given the fact that he has been in for such a small amount of time relative to the amount of time that the state has to indict a case once a defendant is granted bond, nothing further.
Anything else, Ms. Lake? Since you've been so patient and Mr. Lipsy has been so patient, is there anything you want to add, I'll leave.
Thank you, Judge. Your Honor, I agree with Mr. White that the court is to consider a change in circumstance. I believe that I have shown and told the court exactly what the change in circumstances is, that Mr. Lipsy has tried very hard to help the state do its job, and we're still waiting for the state to do its job. And it's not fair to continue to hold Mr. Lipsy in jail and talk about constitutional speedy trial rights or the statute of limitations, both of which I agree with Mr. White on, but they're not, I don't think they're, I don't think it goes to bond. I mean, that's not what we're talking about here. We're talking about whether Mr. Lipsy should continue to be held in custody while we're waiting on the state to bring formal charges against him. Your Honor, the my position is that he is not whether the defense is prejudiced by him remaining in custody doesn't matter. Mr. Lipsy is a human being and he remains in custody. He has been set a bond. The court has already decided that he is entitled to a bond. And if the court is going to set a bond, the court sets a bond with the intention of him posting that bond and giving him an incentive to come back to court when called upon to do so. What we've seen over the past almost 3 months now is that the bond that the court set back in May doesn't accomplish that purpose because Mr. Lipsy isn't able to make it. And so now I'm asking the court to set a bond that he can make and that will incentivize him to come back to court when called upon to do so.
Is he going to live in Fulton County?
Yes, Your Honor. His address is 516 Boulevard Northeast. And that's in Atlanta.
All right. All right. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Sir, when you get out, you'll have a 24-hour curfew. You could leave for court, lawyer, medical, employment. As long as you supply the name of your employer, proof of employment schedule, and the exact location you would be working. No further contact with Tyrence, Tyrence, last name Bernard. I don't know if that was Bernard Tyrence, but yeah, Bernard. All right, so 451 days. All right. What if I cut it in half? Can he make that?
No, Your Honor. How about $451?
Let's see. What if I make it through the 10% program?
Mr. Lipsy, if your bond were, oh gosh, I can't math, about $16,000, $17,000, would anyone from your family be able to pay about 10% of that to the sheriff's department, knowing that they would get that back when your case ends? I doubt it, Judge. I think the best we could do is a couple thousand.
All right. So here's what I'll do. I mean, because it's been 451 days. Don't let me down, Mr. Lipsy. You know, those girls need their daddy. All right. Let me take one thing before I give you these numbers, Mr. Lipsy. What you're teaching these girls is this is the kind of man you look for. This is the kind of man you need to look for. And do you want your girls to marry a man that's in jail and prison? All right. So I want you to get out and you're going to teach your girls what kind of man to look for, right? All right. So I'll do 3,000, 3,000, 1,000, 3,000, and 500. So that's so they have to come up with about what, $1,200. Can they do that? Let's see if they can try. Okay. So you already filed another motion, Ms. Lake. You don't have to file another one since we put it on, but so we can go ahead and put it on again, okay? All right. Thank you. Yeah. Thank you, Mr. Lipsy, for being so patient because I cut it way down. Okay. All right. Thank you, Mr. White. Thank you, Ms. Lake.
Thank you, Judge. Have a good evening.
Thank you. Thank y'all for being so patient. Thank you, Ms. Rhodes. Thank you, Ms. Roberts. Thank you, LT.
And thank all of you for showing up. Oh, wow. I cannot believe so many people showed up for one of my live streams. This is amazing. Thank you, Biggin, for the raid. God, the chat's going crazy. I can't keep up. I'm trying to pay attention to the video over here, too, and read chat. I'm going nuts. Ladies and gentlemen, I do these lives every week. On the week, I do one on Saturday. It's been going on for several weeks now. I think we'll have our 20th episode this coming up Saturday. That's at noon Eastern Standard Time, 11 o'clock Central Standard Time, the best standard time. This is a brand new show, Manic Mondays with Judge Alex Manning, that I am just now premiering tonight. And you're seeing the very first episode. It's a 1 hour-ish long look at some Judge Manning cases, because she just has a unique format that just kind of leans into this live format here. So this is how we're going to do it. We're going to watch Judge Manning together, and we're going to enjoy it. Bill, happy birthday. Victoria said I needed to give you a shout out because it's your birthday, and I'm giving you a shout out because Victoria said it's your birthday, and I needed to say happy birthday. So happy birthday. If I didn't, Phil McCracken, happy birthday. Happy birthday, Phil. Everybody say happy birthday, Phil. I feel like I'm getting punked. I don't know. It's fun. It's all fun. Vic, look forward to seeing you tomorrow during the court. Mel too, the judge. I've got the whole docket today to go through. I didn't get to see any of it, so I'm going to be doing that. We will be doing this again next week, Monday night, 7 p.m. Central Standard Time, whatever that is, Eastern Standard Time, 8 prime time. We'll be doing it live for about an hour. Be having fun. We'll all be saying happy birthday to Phil together again, probably. And while we're saying happy birthday to Phil, we might as well just go ahead and say happy birthday to Dreams and Wi-Fi. Dreams and Wi-Fi just had a birthday like Tuesday of last week, and I'm not sure that we've told Dreams and Wi-Fi happy birthday enough. And everybody say hello to my mother. Hi, Mom. Hi, Mom. And are the dogs here? Where are the dogs? There's the dogs over there. Let's leave the dogs alone. We've had enough. The dogs have been bothered. They have absolutely been bothered. Well, kids, this is all we got. There's no more of the videos. That's done. So, oh my Lord, this happened. Oh, he's so heavy. Look, he came up and said, meow, meow. Say meow. Say meow. I'm a mean cat. I'm the stream boss. Meow. That's the kitty. That's the kitty. That's the kitty. Oh. You gonna stay or are you gonna go? Okay. The chase begins. The chase begins, ladies and gentlemen. Cute, huge kitty. He's awesome. That's my stream boss. That's my everyday boss. That's the dude I work for, ladies and gentlemen. He's the real brains behind everything you see here. He is the brains behind the wolf. If it weren't for that cat right there, none of this would be possible. He is he's first producer, where Dreams and Wi-Fi is the second producer. That's just how it goes. Woo, it's been a fun show, ladies and gentlemen. I hope to see everybody again next time for another episode of Manic Monday with Judge Manning, and maybe even possibly see you this weekend for weekend court reviews on Saturday, live from the gallery. Thank you all for showing up. We'll see you next time.